I think that's a serious misconception. The UAE is a jurisdiction where substantial damages are achievable. Patients and their families have legal rights. They have entitlements. And the Medical Liability Committee take all the steps necessary to investigate the case. They get a copy of the hospital file, they'll interview the doctors, and it's all for free.
Meet Stephen Ballantine, Head of Catastrophic and Complex Injury Claims at Galladari Advocates and Legal Consultants. Widely recognised for his work in serious injury and medical malpractice matters, Stephen has advised on some of the most complex and life-changing cases across the region.
3 sets of proceedings, the regulatory proceedings, the criminal proceedings, and the civil proceedings going on simultaneously. It's very important that you don't jump the gun or act too quickly when assessing a settlement offer. We found that in nearly 80% of cases, the plaintiff recovered 10% or less.
Welcome to Legal POV. In this episode, we look at how victims of personal injury events and their families navigate potentially life-changing or life-shortening outcomes, and legal remedies available to them to obtain appropriate compensation to help them rebuild their lives as best as they can. Joining us is Stephen Ballantine, one of the UAE's leading lawyers in serious injury and medical malpractice matters, and head of catastrophic and complex injury claims at Galladari Advocates and Legal Consultants.
Thank you for that, Aqsa. It's a pleasure to be here. Thank you for the invitation to come here and talk to you about this very important subject.
Due to time constraints, we'll focus only on medical malpractice matters in this podcast, and we'll focus on personal injury sustained in other circumstances in another podcast. What should someone do immediately after any injury sustained in a medical setting?
In my opinion, the first thing that should be done is the patient and the family should focus on the medical aspects of the injury. So that would be focusing on recovery, well-being, and health. The most important thing is your health, not the status of your legal case.
What are the biggest mistakes victims or families make in the early stages following an event?
Good question. The biggest mistakes that victims or their families make after an event is that they tend to focus on the claim itself and they don't focus on recovery and medical aspects. Now, that also could include obtaining second opinions, seeking alternative medical service providers. If they perceive an issue, instead of simply doing nothing, they have to act.
Interesting. I think a lot of people forget that, Stephen, that recovery is important, and then touching base with a lawyer. What medical records or evidence do victims and families make sure they keep?
During the course of normal management of a patient in a hospital or with a doctor, patients go through tests, blood tests, they have MRI scans, they have x-rays, and these reports should be kept. And that's just in the normal course of events. However, if there is some untoward event that happened, it's also useful if the patient or the family take their own notes about what has transpired. For example, if a patient wishes to leave a hospital, it may be that the hospital produce a document called a leaving against medical advice or discharge against medical advice. And it may be that the terms of that discharge or document are not accurate. So in this case, it's really important that the patient or the family make their own notes to record their own perception of facts at that time.
How important is ongoing medical assessment in serious injury cases?
I think it's really important that we focus for a few seconds on the legal remedies available to a patient or the family of a patient who's had a medical malpractice event. The most important remedy available is a complaint to the regulator. Now, the regulator in Dubai is Dubai Health Authority. In Abu Dhabi is the Health Department in Abu Dhabi, and elsewhere it's the Ministry of Health and Prevention. The law, Federal Decree number 4 of 2016, set up a procedure where health authorities like Dubai Health Authority and the Abu Dhabi Health Department, they are required to set up and maintain specialist medical liability committees. Now, these medical liability committees have the sole jurisdiction to investigate complaints of medical error, medical malpractice, and also they have exclusive jurisdiction to look at disability and whether there's a causal link between the error and the damage or injury. And that's a really important step. From that process, the Medical Liability Committee makes a report, and if the patient or the family of the patient or the hospital or the physician, if they disagree with the decision of the Medical Liability Committee, they have a right to file an appeal to the Supreme Committee or the Higher Committee of Medical Liability upon payment of a fee of 5,000 dirhams, and they must do so, they must file an appeal within 30 days of the date that the Medical Liability Committee report was published. Another remedy available is a complaint can be made to the police or the public prosecution, because medical malpractice is a crime as well as a civil wrong. So medical malpractice is a crime, and a physician or a surgeon or a hospital that have been found guilty of medical malpractice causing injury could be a substantial fine, or it could actually be a custodial sentence. So the penalties available are quite serious. Now, the objective of the criminal proceeding is to punish and to deter. It's not there to compensate a patient. If someone wants compensation, then they have to go to the civil courts to file a case claiming compensation. And the law says that if you want to do that, then you have to have a report from the Medical Liability Committee. It's sometimes possible to have the regulatory proceedings in place and in running. So someone makes a complaint to the Medical Liability Committee via the health authority. That case can be running. It's also possible that a victim or their families can make a complaint to the police. And at the same time, the family or the victim of medical malpractice can make a case in the civil courts. So it's possible that there can be 3 sets of proceedings going on at the same time. Now, what happens there is that the public prosecution or the police will take a decision not to proceed with a prosecution until the Medical Liability Committee has produced a report. If an appeal has been filed, it is possible then to have 3 sets of proceedings, the regulatory proceedings, the criminal proceedings, and the civil proceedings going on simultaneously. Now, in those circumstances, what happens is that the police or the public prosecutor will usually say, okay, we're not going to prosecute until we have a final Medical Liability Committee decision, in which case the public prosecution or the police, they'd also take into account whether any of the parties have filed an appeal to the higher committee. And usually what they would do is say, okay, we're not going to do anything until we get a final report from either the Medical Liability Committee or the higher committee. Similarly, if the parties also file a civil case, you need to have a Medical Liability Committee report to actually file the case in the first place. However, if evidence is given to the court that an appeal has been filed, copies of the appeal submissions, an email from the DHA acknowledging receipt of the appeal, then the civil court will stay the proceedings pending determination of the higher committee report. And that finding is probably the most important throughout the whole proceeding of the case. Because unless the parties take advantage of a further proceeding, which is to file a case challenging the higher committee report before the administration court in Abu Dhabi, then the higher committee report is final and can't be challenged. So the finding of the higher committee of either no medical error, or gross medical error is the important factor.
I believe the long-term prognosis of a serious injury documented through an independent expert report is important. Stephen, can you touch light on the medical assessment in serious injury cases? Do people sometimes underestimate the long-term impact of an injury too early?
That's a really good question. In my experience, issues of liability, i.e., is there a medical error or isn't there a medical error? Is there a gross medical error or isn't there a gross medical error? Are really important issues, but they're determined reasonably early on in the various remedies that are available. So the Medical Liability Committee and the higher committee process is key and it's central to everything. The objective of criminal proceedings is to punish and to deter. So no compensation is awarded, and there is no real examination of the long-term effects of an injury or a disability. It's really about the act itself, the error itself. It's only in the civil case where the court will assess the long-term impact of a disability or an injury. Now that's there for one particular reason, and that's to assess compensation. So it's really, really important that the medical evidence supporting the impact of a disability, for example, if one has an injury and a disability, they may need long-term physiotherapy. They may have to undergo a series of remedial operations or surgical procedures to help them recover. It may be they have to have several months where they can't work and they can't do the job, they can't earn a living. So the long-term assessment of the impact of an injury or the disabilities involved is really, really important. And that, I'm afraid, is something that many, many patients and their families and their lawyers ignore. So it will be the case that the lawyer in a case like this, where they're filing a case for medical malpractice, only files evidence of the higher committee report or the medical liability committee report establishing liability. That's only half the battle. That's only half the battle. The other half, the important half, the most important half, is how much damages can I achieve? And to do that, one has to look at evidence. The evidence of a medical expert that can look at and assess and write about the long-term impact upon someone's life due to a serious or catastrophic injury is probably the most important evidence. Secondary evidence could be if your flat or your house requires some modification, like a ramp for a wheelchair or special equipment for a bathroom, so access for a bath or a shower. These quotations to do this work are also really important because it's not only about medical treatment, it's about the long-term impact upon your standard of life and how you live your life.
So important. Just to think about it, a serious injury is not just in that moment. It can have such long-term impacts. Lifetime therapy, having to leave your career forever. It impacts your family life, maybe chances of having a family. It's not just financially distressing, it's emotionally distressing too.
Well, you're absolutely right, Aqsa. It's not just about getting medical expenses or loss of earnings. It also has to compensate the family for a loss. Take, for example, a catastrophic birth injury. Now, these are probably one of the most serious type of injuries that the courts will see. A fetus has, a typical case is a fetus has an umbilical cord wrapped around his neck. It restricts breathing, it restricts blood flow, and becomes weakened. And the medical team, for whatever reason, do not deliver the fetus as soon as they should. Now, if the fetus has suffered hypoxic ischemic encephalopathy, which is a fancy term for excessive brain damage, then that can impact upon not just the life of the child who has the disability, who needs all the support, who needs therapy, but also impacts upon the lives of the parents who are not just getting the healthy bundle of joy that they expected, but they have to spend inordinate time looking after the infant. Sometimes they have to give up their jobs. Sometimes they have to take lesser paid jobs if it means more access for looking after the child. And of course, it has an impact upon the siblings, the grandparents. If your parents are focusing on your brother or sister who has really serious injuries and disabilities, then you're not getting the attention that you need as a child. So it impacts upon every aspect of the life in a serious and life-changing way.
Is liability usually the real issue, or is the challenge more about proving the extent of the damage and long-term impact? How important is evidentiary support in claiming damages?
Good question. Liability is, of course, a constituent part of any claim. There must be liability, but the Medical Liability Committee and the Higher Committee of Medical Liability process sorts that out really at a very early stage, i.e. before court. So liability is established really before you go to court, which means if you can't establish liability, if the finding of the Medical Liability Committee or the Higher Committee is one of no error, you know that it's 99.9% likely that if you file a case, you will receive no damages and your case will be dismissed. So really it's up to you whether you want to proceed in those terms. If you file a Medical Liability Committee report finding no error, I think the answer speaks for itself. By the time you get to court, medical liability or liability for medical error or gross error is established. As I say, apart from the procedure where you can challenge higher committee reports in the administration court in Abu Dhabi on the grounds that the higher committee report is somehow flawed, leaving that aside for a minute, the reports, the findings of the Supreme Committee and the Medical Liability Committee are accepted really at face value by the civil courts. Now that's really, really important because if you have a Supreme Committee report finding gross error and there are permanent disability, you will obtain damages. The question is how much, which is why obtaining documentary evidence to prove your claim is so very important. So you're right. The most important thing, in my view, is not about establishing liability. That's done for you by the higher committee and the Medical Liability Committee. You are on your own when it comes to proving your loss. Now, in a case, say, involving a catastrophic birth injury, how would we go about evidencing this? Well, the first thing that you have to do is appoint an expert in pediatric neurology. Now, in different areas, you get medical experts qualified in that area. But for a catastrophic birth injury, where there's substantial brain damage, you would expect to see the patient or the patient's family obtain a report of a pediatric neurologist who's able to assess fully the long-term care required for some child who has the level of disability that the higher committee have found. I've just done a case recently where we had a very good pediatric neurologist prepare an excellent report. We also obtained estimates and quotations for the provision of specialist equipment. It may be the case that if a child, because of the severity of the disabilities, can't be looked after at home, when the challenges are too great to keep a child at home and look after them at home, specialist nursing care, special equipment, specialist lifting equipment, and just all-round nursing care and attention, then there are certain institutions that offer 24-hour inpatient care, which means there will be hefty bills. Now, that has to be assessed because, of course, the function of compensation is to compensate you fully for your losses. So, a report which sets out all of the expenses that you could expect to see, a quotation for all of the non-medical essentials, the ramp for the wheelchair, the lifting equipment, access to bathing, that sort of thing, then that is a 360 view to evidencing your claim.
You've been a medical malpractice lawyer in the UAE for the last 3 decades. So from your experience, what do medical liability insurers assess in these cases?
I've been a medical malpractice lawyer in Dubai for 28 years, and I have been instructed by medical malpractice insurers, and it generally looks like this. The first thing that we have to do is look at the facts of the case and investigate. Now, if there already is a finding of medical error or serious medical error by the higher committee, essentially, the investigation into liability, is there a fault? Did someone do anything wrong? Essentially stops. We then focus on quantum, which is how much a claim is worth. We've done lots of research into this, and we looked at some medical malpractice cases where liability was established over a period of 10 years that had been adjudicated in the courts of the Emirates of Dubai, Abu Dhabi, and Sharjah, which is about 75 cases over 10 years, so it's quite a significant sample. And we found that in nearly 80% of cases, the plaintiff recovered 10% or less than their claim amount. Now, there's a number of reasons for that, but in our assessment, it's largely due to the fact that plaintiffs and their lawyers tend to focus on liability only, and they don't focus enough, or in some cases at all, in evidencing their claims for quantum, the amount of the claim. There's also another important thing that lawyers for medical malpractice insurers look at. And this is something that may surprise a lot of people, but what they're asked to do is look at whether there's any potential for settlement. If error is established, compensation will follow. The question is how much. So a lawyer like me or someone else would be asked to look at how much should the claim be settled for. And that's the really important part that patients or their families should realize that isn't necessarily a position where parties are locked in to litigation. Once the finding of medical liability committee and the Supreme Committee establishes error, in my experience, hospitals and insurance companies are much more likely to look at settlement at reasonable levels.
You mentioned earlier the importance of focusing on medical attention and recovery in the initial stages. So realistically, at what stage does someone speak to a lawyer? How does someone determine that? Do you suggest that different circumstances would require intervention of the lawyer at an earlier rather than later stage?
Well, look, it may well be the case that a lawyer's intervention is required even before the parties really realize there's an error. And that could be there's a disagreement about a course of treatment. There's a disagreement about a factual situation that's arisen, that may well justify a patient or a plaintiff or even a hospital and the insurance company from taking early advice. But in my experience, what usually happens is that in the normal course of events, an error has taken place or an incident has taken place. The patient or the family recognize that there's something gone wrong, and they address this with the hospital or the physician and say, hey, something going on here, or we don't like this, the way it's developing, or this outcome is not what we expected. And that may be an appropriate juncture to get some background advice. Now, lawyers aren't medically trained, so they can't tell you whether a doctor or a hospital made a mistake. But what they can do is just advise you on what your legal remedies are. So once we get through that stage and the parties are pretty convinced, or the patient and the family are convinced that there's been an error and it's been addressed with the hospital, if the hospital or the insurance company or the physician, they feel that a settlement is to their advantage or to everyone's benefit, that may be a time that you want to get a halfpen's worth of legal advice. Simply because, and I've seen this many times, sometimes patients and their families do not take their medium to long-term prognosis properly into consideration. In my view, there is no point settling a case if your medium to long-term prognosis is still uncertain. It may well be in that situation, if you do settle the case and you do sign a settlement agreement and you do accept a sum of money, the chances are that the agreement will be drafted that you can't go back for more if your situation deteriorates or worsens. So it's very important that you don't jump the gun or act too quickly when assessing a settlement offer.
And that's where the lawyer comes in.
A lawyer can give advice about this, but generally, in most cases, from a plaintiff's point of view, I get approached all the time by patients or their families who have an issue with their hospital or the medical service provider, and they ask me, I want to make a complaint to the DHA, the Medical Liability Committee, or whatever health authority is involved. Can you help me? I would usually say, well, look, you don't need a lawyer to do this because the committee isn't really looking at the legal aspects. They're not there to assess compensation. They're only really there to assess medical issues. So the advice I would give them is, provided you describe what happened clearly, in chronological order, and specifically, that's the best thing you can do. I don't think you need to expend fees on legal bills to help you with this. What I do expect to get calls about is if there's a medical liability committee decision which the patient or the family disagree with, that would be there's no medical error. Or maybe there's a medical error, but it hasn't caused any serious disability, or it challenges or hasn't described the causation effect between the error and the damage. That's when I think you need to approach a lawyer, because the appeal process is quite technical, and I think it needs forensic skills of a lawyer to help you best put your case forward. It's also a time that I would recommend, in most cases, that instead of a lawyer simply drafting submissions, that the patient or the families listen to the advice of the lawyer and find a suitably qualified medical expert to help explain why the family or the patient disagree with the Medical Liability Committee findings, and indeed why they say that the Medical Liability Committee findings are wrong or flawed.
What are the key differences in the UA process compared to countries like the UK or elsewhere in medical malpractice?
Yeah, that's a good question. Obviously, other countries that have different legal jurisdictions handle medical malpractice cases in different ways. For example, in the United Kingdom, simple medical error or medical malpractice is not a crime. It's a civil wrong. Also, there are regulated proceedings for doctors or hospitals who don't achieve the required standards. The other way is that courts in the United Kingdom have a much greater latitude to award damages. In my experience in the United Arab Emirates, the courts tend to award damages at a much lesser scale. So, for example, in a case of catastrophic birth injury, where a child has sustained life-changing permanent disabilities, can't see, can't hear, can't speak, can't walk, can't touch, can't feel, can't use their limbs, the scale of damages that that child would receive in the UK are far greater. It can be as high as maybe 30 or 40 million dirhams, whereas in the UAE courts, the damages awarded are much less. Now, the other difference between the UK and the United Arab Emirates is the unique way of investigating and determining liability. The UAE has the system, as I explained earlier, of medical liability committees having sole jurisdiction to review and investigate whether there's a medical error, whether there's any disability, and whether there's any causal link between the error and the disability. That's fairly unique. The UK doesn't have that. It really is a series of adversarial exchanges where the plaintiff has a medical expert and the defendants, the hospital or the physician, they have their medical experts and they both have their own reviews of the events in question. Then the court will ask the experts to meet and to agree what they can and set out a list of issues that they don't agree. And then the court will decide on those issues. Now, I much prefer the system in the United Arab Emirates, I must say. It's a lot easier, it's a lot cleaner, and the committees involved, the Medical Liability Committee and the Hire Committee, are not being paid by anyone. They're not being paid by the plaintiff or the defendant. So they are much more objective.
From your perspective, what is the biggest misconception people have about serious injury cases?
From my perspective, what I'd say is the biggest misconception is that patients or their families or victims of any personal injury case for that matter feel that it's not worth it. It's not worth going to court, or they're so unfamiliar with the process or the proceedings that they question whether it's a worthwhile process to file a case or make a complaint. Of course, I think that's a serious misconception because the UAE is a jurisdiction where substantial damages are achievable. Patients and their families have legal rights. They have entitlements. They have the ability to file a case with the Medical Liability Committee, and the Medical Liability Committee take all the steps necessary to investigate the case. They get a copy of the hospital file, they'll interview the doctors, and it's all for free. So that's one aspect. But one thing that's really, really important that victims or their families should realize is that support is available. They have people, they have skilled lawyers who are experienced in these cases who are there to help them. They shouldn't feel alone. They shouldn't feel hopeless. They should be determined enough to approach someone they trust or someone they've been recommended to see, someone with experience and the necessary skills to represent them and to help them get the compensation they need.
Stephen, thank you again for sharing your insight and experience with us today. I think this conversation highlights something very important in serious injury cases. The decisions made early can shape recovery, support, and long-term outcomes far more than people realize. For victims and families, understanding the process early is not only about protecting a claim, it's about protecting their future. Thank you for joining us. Until next time, another day, another legal POV.